Hello, everyone. This is Corey Talbot. I'm a partner at Holland & Hart. Welcome to the latest in our series of webinars on healthcare issues. Today, we are going to be talking about responding to noncompliance. This is repaying overpayments and self-reporting. If you have questions along the way, feel free to type them in, and we'll get those. I am hoping to be able to respond to them, but just a heads up that unfortunately I have a meeting on the back end of this, and so I'm probably not going to be able to get to questions during the webinar, but if you have questions and ask them, I will respond to those after the webinar by email. So feel free to ask questions along the way. Just please understand it may be a day or so before you get a response from me. So with that, because we are in a bit of a hurry, let's go ahead and get started. This is what we're talking about today is a problem that people usually don't have, which is, what do? I have too much money. In this case, that is a problem. If we have been overpaid, we need to figure out what to do and how to get those funds to where they belong. Okay, so we're going to start out by talking about where this applies, and this comes from the 2010 Affordable Care Act, which requires a person who has received an overpayment to report and return the overpayment to the relevant federal agency, the state, an intermediary, a carrier, a contractor, and in addition to that, to explain, provide a notice to the entity of the reason for the overpayment. And in the wake of this provision in the Affordable Care Act, the Civil Monetary Penalties Law was revised, as was the False Claims Act, to require repayments of overpayments. So if a provider has received an overpayment, they have to return that to the federal agency, state intermediary, character, notify them of the reason for the overpayment. So this applies to overpayments. And what does that mean? As you can see, it's any funds that you receive or retain from Medicare or Medicaid to which the person, after applicable reconciliation, is not entitled. That is what we're talking about as far as an overpayment. All right, some examples, very helpfully actually in the commentary that came along with the new rule. They provided, CMS provided some really helpful examples of when this comes up, examples of overpayments, payments for claims submitted in violation of Stark Law or anti-kickback statutes, payments for non-covered services, payments in excess of the allowable amount, errors, non-reimbursable expenses, cost report, duplicate payments, receipt of Medicare payment when another payer has primary responsibility. So that is, that's where, those are some examples of overpayment. Now, I do want to note a difference between conditions of payment versus conditions of participation, because those do not always overlap. So condition of payment, those are the things in the Medicare regulations that say, hey, before you send us a claim, you've got to do this, that, or the other. Okay, it's a condition of payment, just like it says. You've got to comply with this. We only pay for this. We're only going to pay you if you do that. Those are the types of things violations give right to that create that overpayment situation. Now, contrast with that, conditions of participation. So condition you have to satisfy to take part in Medicare or a Medicaid program, not necessarily a condition of payment. So you could violate a condition of participation without necessarily violating a condition of payment. So, for example, just because you violate the Medicare conditions of participation because, say, you don't have the right purposes in your bylaws or something like that, in that situation, it doesn't necessarily mean you've got an overpayment issue. You violate state licensure regulations, you generally don't have to a repayment obligation, except to the extent that if the condition of payment is you must be properly licensed to submit the claim and you're not licensed, then you would have a payment obligation. But I mean, think violation of HIPAA, violation of EMTALA, OSHA, those sorts of things. Usually not a condition of payment, and so wouldn't give rise to a repayment obligation under the Affordable Care Act. How far back do you have to go? 6 years. That's our look-back period. Overpayments have to be reported and returned if they're identified within 6 years of the date the overpayment was received. Okay, so penalties. The penalties for not timely returning and repaying the overpayment come from a number of sources. The first that we're going to talk about is the False Claims Act. False Claims Act imposes liability on people who defraud government programs. And the False Claims Act defines the prohibitions that give rise to a claim in the overpayment context. First, knowingly submitting or causing to be submitted false or fraudulent claims. Not surprisingly, that is a problem. Knowingly making, using, or causing to be made or used false records or statements that are material to a false or fraudulent claim also give rise to a claim under the False Claims Act. And then there are the so-called reverse false claims that can give rise to an action. And that's where somebody knowingly conceals or knowingly and improperly avoids or decreases an obligation to pay or transmit money or property to the government. And so an overpayment that is retained after the repayment deadline, which we'll talk about shortly, is considered an obligation for purposes of the False Claims Act. Penalties under the False Claims Act, this is where you get treble damages, which are 3 times the actual damages. You can incur penalties of approximately just over $11,000 to just over $22,000 per violation under the False Claims Act, and you can find yourself subject to a key TAM lawsuit where relators file a lawsuit, and they receive a percentage of the ultimate recovery, if any. Another source of penalties for violating the overpayment provisions of the Affordable Care Act is from the civil monetary penalty law. Very, somewhat similar, I think, to the False Claims Act. You can have a $10,000 penalty, approximately. Treble damages, again, 3 times the actual damages, and notably, exclusion from Medicare or Medicaid. Now, the number of cases that are being filed on overpayment and the recovery amounts are rising. Here's an example of a case in 2016 that gave rise to a $3 million settlement agreement. And so these are real issues, and so you want to pay attention. If you're getting overpayments, you need to figure out what to do with those to make it right. Okay, when does the clock start ticking for you if you have an overpayment? Okay, the rule sets out, the CMS rule, which was published in February of 2016, sets out a 60-day timeline to do that. And you have to report within 60 days after the overpayment is identified or the date that a corresponding cost report is due. And we're going to talk quite a bit about that 60-day requirement, what it means to identify an overpayment. But the date that a corresponding cost report is due, wanted to flag that because that was the subject of quite a bit of commentary when this rule, when CMS issued this rule. In some circumstances, Medicare makes estimated payments for services with the knowledge that a reconciliation of payments to what the actual costs is going to be done when the actual costs or related information becomes available. And that typically isn't at the time that the estimated payment is made. It usually comes later. And so the commentary on the rule says that interim payments made to a provider throughout the cost year are reconciled with covered and reimbursable costs at the time the cost report is due. And so the way that works is the definition of the term overpayment acknowledges this. And what it does is it provides an overpayment doesn't exist until after an applicable reconciliation takes place. So when the provider files a cost report, the provider is reporting the provider's reconciliation and attesting to the accuracy of the information on that cost report. So providers have to maintain the appropriate documentation supporting their costs that are claimed on the cost report. And what the CMS said in issuing the rules is, we stated that we rely upon information that providers submit through the cost report, whether it is an initial submission of a cost report or an amended one. We believe providers must accurately report any cost-related overpayments at the time they submit any cost reports to CMS. Okay, so those comments from CMS are set out in the CMS regulations that were issued in February of 2016, and I strongly, strongly recommend that you take a look at that commentary that accompanied those regulations. It's really, really helpful information. Okay, now let's talk about that 60-day rule, and just to flag that is a provider must report and return an overpayment within the later of 60 days after the overpayment is identified. Okay, so we're going to be talking about that prong of this test. So how do you identify the overpayment? It's a two-step process. So a person has identified an overpayment when the person, one, first has or should have, through the exercise of reasonable diligence, determined that the person has received an overpayment, and two, quantified the amount of the overpayment. And so overpayment requires that quantification. You have to exercise reasonable diligence, and so that standard reasonable diligence, it includes proactive compliance monitoring and reactive investigations in response to credible information of a potential overpayment. And the commentary makes this clear too, that if you take only minimal compliance activities to monitor appropriateness and accuracy of claims, would be a failure to exercise reasonable diligence. Now, reasonable diligence is a fact-dependent inquiry, and so that really is something where we don't have a whole lot of guidance in interpreting that reasonableness. Beyond that it is a fact-dependent inquiry from the agencies. So it's either actual knowledge of when it talks about it has or should have determined, that's actual knowledge, or reckless disregard or intentional ignorance of a potential claim. So now the government says that the person you identify the overpayment when you should have discovered it, even if you don't actually discover it. So they expect you to engage in reasonable diligence. And that means you have to engage in proactive monitoring. You can't just sit there and do nothing. The CMS gave an example of this in the comments accompanying the rules, and the example they gave is, what if you get, for instance, a compliance hotline complaint about a potential overpayment that occurred, and it was sufficiently enough, the phone call was sufficiently credible that triggered your duty to investigate the matter. If that happens, if the call is sufficiently credible to trigger that duty, the provider then has that duty to diligently conduct an investigation, report and return any resulting overpayments within the 60-day reporting and repayment period. Then they've established that. But if they fail to, and the clock, that 60-day clock starts ticking after they have completed that investigation. So once you have credible information, what you do is you begin your investigation. Once you actually then, through that investigation, determine that, yes, you've received an overpayment and quantified the amount of the overpayment, that's when the 60-day time starts to run. But if you ignore that, if you don't pay attention to it, and you take no steps to investigate it, the 60-day time period starts to run as soon as you should have made reasonable inquiry into the complaint. So some more examples that CMS provided. If you identify a single overpaid claim, that's going to require you to make further investigation. Some specific examples they give. If you find that you have significant and unexplained increases in your Medicare revenue, nothing's changed except the amount of the dollars in the door that you're aware of, that's going to trigger a duty to reasonably investigate whether there have been overpayments. If you, in a review of bills, you actually discover that there have been incorrect coding, that's going to trigger a duty to investigate that further, and then some of these other ones as well. Services rendered by an unlicensed provider, if you discover that. If you have an audit that discloses overpayments, discover AKS, Stark, or CMP law violations, all those would give rise to a duty to reasonably engage in reasonable diligence in investigating whether there has been an overpayment. Okay, and then the second part of that rule, again, goes to quantifying the amount, which requires a reasonably diligent investigation. And this is really important because for you to have that, for the 60-day rule to apply, you have to be able to quantify that amount. And that can take some time to do because, there may be instances where, for example, you need to bring in outside auditors or outside legal counsel to conduct the investigation. And all that has to be done in a reasonably diligent way, but while that's ongoing, the clock is not ticking on that 60-day deadline, okay? All right. So after the clock starts ticking, when you've identified that there's a potential problem, you've quantified the amount, then the clock starts. And in the alternative, if you don't exercise reasonable diligence, the day you receive credible information of the potential overpayment, that's when the clock starts ticking. Now, if you are conducting an investigation, how long do you have? Typically, it has to be done within 6 months. And so that's really sort of the outside window. Now it can be extended in extraordinary circumstances, but 8 months is generally the total time to return overpayments. And so when I say 8 months, that's your 6 months to conduct and complete your investigation to identify and quantify the amount of the overpayment, and then you've got 60 days after that to return the overpayments. Do this as part of that process. Document, document, document. Make sure that you have a really good paper trail of the reasonable diligence that you are exercising, of the investigation that you're doing, so that if there are problems and an agency comes knocking at the door, you've got that information available to show that you took the appropriate steps. Okay, so now let's say we have an investigation, we have discovered an overpayment, it's been quantified, and the 60-day clock is ticking. What if you decide, we've got a serious problem, we think this may be a violation of the anti-kickback statute, civil monetary penalties law, we need to self-report, or you have a Stark problem, and you think that you need to report to CMS. In those cases, if you do that, it tolls that 60-day clock. So the clock stops once you engage in that the self-disclosure protocol with OIG or the Stark self-referral disclosure protocol with CMS. And also, you can, in some situations, the rule contemplates that if you figure out you owe a lot of money and you can't repay it all at once, you may be able to enter into a repayment schedule with the carrier. And so in that case, you may not have fully repaid that within the 60-day period contemplated by the rule, but you can enter into a repayment schedule with the carrier, and that would be appropriate for you to do. Okay, so what do you do then if you've determined that you have an overpayment situation, you're within your 60 days, and you want to know, okay, what do I do with this money? The first is the Medicare Administrative Contractor. You can give it to the MAC, and for that, what you do is if it's and this is generally probably where you want to go because it's the cheapest and fastest way to do this. And so if you've got simply, there was an overpayment received, it's a claims adjustment, credit balance, self-reported refund, something like that, go to the MAC and provide it there. And then if the Medicare contractor rather believes that repayment involves violation of federal law, the contractor can report that to OIG, CMS, or any other federal agency. But, and I put up the example of Noridian. You can get on their website and run through that process to report and repay the obligation. Okay, so that is going through the MAC. That is not always going to be, though, the way that you want or need to go. And where you have situations, the other alternative is to go to the Office of the Inspector General or to CMS. CMS has been pretty good, actually, in stark disclosures. They're good to work with. OIG, not so much. I mean, if you report to OIG, they are fraud investigators, and once they're looking around your facility, they can look at anything they want, and so the scope of their investigation can broaden pretty quickly. So you need to be careful before you start down this path to know, is that really where you want to go? There are appropriate situations where you need to. Where there was a violation of the law, and you're not going to be able to do the repayment to the government because it's so much money, you can't just write a check, so you have to go to OIG. But be careful before you do, because once you start down that path, you may not be entirely sure where you're going to end up. So preferred method, again, go back to the MAC, go to Noridian, go to your the MAC that you're working with, or in case of stark violations, go to CMS. But there are situations, of course, where you need to go to OIG. Making the disclosure, making repayment to the MAC, by the way, this does not absolve you from anti-kickback liability or Stark law violation liability. OIG or Department of Justice can still come after you for violation of other laws, but you're probably going to be okay as long as there's not a showing of gross misconduct or intentional violations. So normally we like to go to the carrier because you can avoid getting OIG involved. If it's a bad situation, the carrier or contractor may report you to OIG or CMS, but at least, if it's not a clear violation, I'd recommend you go to the contractor. If it is a serious violation, though, you'll want to go to the OIG website. They have specific protocols for the OIG. It's basically that you're admitting there's a violation of law, which means you're admitting they can you can get hit with additional penalties. So you want to make sure you do your homework before you go to OIG or CMS. This is necessary, though, for overpayments that are going to require a settlement agreement. You'll want to do this and go through this process. If you submit, it does suspend the 60-day requirement to return overpayments until a settlement agreement is executed. Self-disclosures to other agencies, though, do not suspend the repayment deadline. So, for instance, if you have a situation you're concerned and you go to the Department of Justice, that is not going to suspend the repayment deadline. If you go to the state Medicaid office, not going to suspend the repayment deadline. Repayment does not resolve violations or penalties under other laws either. So, for instance, if you go to CMS for an issue that's a Stark law violation, you can have it resolved there. But if there are also elements, say you've got anti-kickback statute involved too, CMS can't absolve you of liability for that. You've got to go to OIG. Okay, now what's missing from the rule? What does the rule say about Medicaid? Well, the regulations don't apply to Medicaid, but the Affordable Care Act does. So the repayment requirement in the Affordable Care Act does apply to state Medicaid. And so providers have to return and report overpayments to Medicaid within 60 days of identification, notwithstanding the lack of guidance on that issue. And so what you can usually count on from states, you could be penalties for failing to do that can include exclusion from state health programs such as Medicaid, civil penalty per violation, referral to the Medicaid fraud unit. And so you want to take this returning and reporting obligation seriously in Medicaid situations as well. Medicare Part C and D, at least one court has found that failing to return and report overpayments in the Medicare Advantage creates liability under the False Claims Act. And so again, it's important to comply with this. For Medicare Part C and D rather, note CMS has issued rules in May of 2014 that address that. And in addition, the commentary with the final rule in February 2016 had this to say about Medicare Part C and D. We remind all stakeholders that even without a final regulation, they are subject to the statutory requirements found in the Affordable Care Act and could face potential False Claims Act liability, civil monetary penalties law liability, and exclusion from federal health care programs for failure to report and return an overpayment. Additionally, providers and suppliers continue to be required to comply with our current procedures when we or our contractors determine an overpayment and issue a demand letter. And so while the 60-day rule does not directly apply to Medicaid, Medicare Part C and D, you'll want to make sure that you are still complying with that reporting and returning overpayment obligation under the Affordable Care Act. Okay, next. What about the situation where you have not complied with regulatory requirements? Can that be a situation where that creates an overpayment? And this is the issue the U.S. Supreme Court addressed in the Escobar case, which is about 3 years old now, and you've probably all heard a little bit about it, and the implied certification theory that the court endorsed in that case. So what happened in Escobar? Defendant submitted billing codes to Medicaid. They corresponded to specific counseling services along with NPI numbers, corresponded to specific job titles. And the court said, okay, that's a representation to Medicaid by the defendant, sorry about that typo there, that it provided the services through the professionals with certain qualifications, and when in fact the defendant's professional staff did not have those qualifications, and that the failure to have those qualifications means that they did not meet the Medicaid requirements. The court determined that the government would not have paid the claims but for that misrepresentation, and so as a result, what the court found in that case was False Claims Act liability can be founded on noncompliance with requirements that are not express conditions of payment. This is the implied certification theory. That doesn't mean, though, that all noncompliance creates False Claims Act liability. What Escobar did is provide us with a framework that we can look at for this implied certification issue. And again, this is where it's not an express condition of payment, but it's an implied certification of something that would be taken into account in the decision to pay the claim. So that the framework has we got three things we look at. One, the claim makes a specific representation about the goods or services provided. Two, the defendant knowingly failed to disclose noncompliance with material statutory, regulatory, contractual requirements that turn those representations into, in the Escobar case, misleading half-truths about what was happening. And then three, the misrepresentation is material to the decision to pay the claim. And that was the case in Escobar. What is material? Well, evidence the defendant knows the government has consistently refused to pay the claim. That was the case in Escobar. And then two, did the government have actual knowledge of the noncompliance yet continue to pay the claim? That's another indication of whether the issue is material. If Medicaid knows that that these licensing qualifications weren't met in Escobar and continued to pay anyway, well, maybe those aren't material in that case. In that case, though, the government proved that it was material. Okay, so where does that leave the analysis for purposes of the 60-day rule? Well, Escobar doesn't provide us with any examples of what meets that implied certification theory beyond the facts of the case. But it does help us because it gives us that framework that we can look at for regulatory requirements, and we can walk through those points to try to figure out if this is a case that implied certification theory would apply. And so what we're seeing now is throughout the country, you've got cases that are starting to flesh out the meaning and requirements in Escobar. Okay, but at this point, on the 60-day rule generally, though, court decisions have really turned on procedural issues rather than the merits of the CMS 60-day rule. And so as you're looking for guidance and enforcement, you'll want to make sure that you carefully look at the procedural posture of cases that are addressing the 60-day rule. Most of them have come in, for example, a party is involved in claim for an overpayment, they file a motion to dismiss, and there are certain procedural standards that govern a motion to dismiss that may not impact the merits of the 60-day rule. And so those are the types of cases that we've been seeing that discuss the 60-day rule. They're really dependent on the procedural posture of the case rather than the merits of the 60-day rule. We have seen quite a few settlements, though, there's a couple examples that I flagged here. Genesis Medical Center, it's a $1.8 million payment to resolve allegations of overpayments due to incorrect coding. They should have been billed as outpatient or observation services rather than admission claims, and that would have resulted in lower reimbursement. University of Rochester allegedly used an ophthalmologic, easy for me to say, modifier to increase reimbursement, entered into a settlement agreement as well. Note, as we were talking about self-disclosure, University of Rochester had self-disclosed to learning about a related previously filed qui tam complaint, and that was taken into account. Okay, so when is self-disclosure appropriate? I mean, what you want to ask is, does the issue involve a potential violation of law, right? I mean, if it's a matter that just involves an overpayment, not a violation of Stark, anti-kickback law, that sort of thing, just go to the MAC and go through that process. But if if you're looking at something you think, gosh, we probably violated Stark here, that's when you want to consider self-disclosure. Is the provider operating under a corporate integrity agreement? That may answer your question for you. Benefits of self-disclosure, let's talk about the pluses and minuses first. It's likely that your repayment amount will be lower than if the agency has to chase after you, and by the same token, it's less likely that an investigation will lead to a corporate integrity agreement. You're likely to get releases which will protect against certain types of liability, and we'll talk about that a little more detail shortly because it's hard to get a blanket release from liability from the different agencies. You have to involve multiple agencies if you want to do that. It's also self-disclosure is less likely, doesn't eliminate it, but it's less likely the government will do its own more intrusive investigation, and you can get better protection for individuals. The risks, though, the agency may not limit its review to the issues disclosed. Again, I mentioned this earlier with the OIG. This is a fraud investigation, and you're inviting in fraud investigators, and they are not limited to the issues that you self-disclose. And the fact is that with the complexity of the fraud and abuse laws, it can lead to unnecessary disclosure and liability. There's also no guarantee of leniency or immunity, any specific benefit of going. It's less likely that you'll have problems with this, but it doesn't mean that you're guaranteed that this will happen. Providers may not be accepted into the protocols for self-disclosure. And again, as I mentioned, disclosing something to one agency may not, you may be able to resolve that with them, but it may not resolve your liability to another agency in another context. And the timing can be an issue too. The fact is that sometimes their investigations take a long time, CMS especially. Okay, so before you do self-disclose, you'll want to make sure that you identify all the laws that you've potentially violated, identify the relevant time frame when the potential violation or violations occurred, so that you've got this as much as you can, sort of an understanding of what you're getting into. Take action to correct the non-compliant practice and to prevent it from happening again. And again, this may not be enough to keep you out of trouble, but it'll certainly help. And then as you're self-disclosing, you need to understand you're going to have to acknowledge the potential violation, and you're going to need to cooperate fully with the investigating agency. So I'd strongly recommend take a look at the disclosure protocols for CMS, for OIG. They're online. Contact your compliance officer and consider contacting a knowledgeable attorney, all of which can help to set yourself up so that if you do need to self-disclose, you're putting yourself in the best possible position that you can be in. Okay, where are you going to self-disclose? You don't just get a pick. If you're dealing with conduct that involves false billing, excluded persons, anti-kickback statute, you've got to go to OIG. As I know, if it's anti-kickback and Stark law, you need to go to OIG. CMS, the self-referral disclosure protocol, only covers violations of the Stark law. And so you've got multiple violations. You're going to have violations of multiple laws. You're going to have to go to OIG. DOJ, if you think you're going to need a False Claims Act release, you want to report to DOJ. Remember, that doesn't toll the 60-day rule if you go to DOJ. That only is through the protocols of CMS and OIG. So if you do go and self-disclose to the Department of Justice, that does not stop that 60-day clock from ticking. And then go to the MAC, and again, that's usually the best for relatively simple overpayments. You don't get a release, but it's usually the least expensive route. Let's talk about going to OIG. You've got to, say you've run into a case where you found anti-kickback and Stark issues together. You want to go to OIG. The upside, it does toll that 60-day deadline to report and repay. It releases you from liability under the civil monetary penalty law and from permissive exclusion. So that can be a real benefit to individuals involved in this to have that issue dealt with through OIG. Lower multiplier on single damages, often 1.5 times actual damages, which is better than it can be. And other potential damages are likely going to be reduced. And OIG is, you can usually get pretty expedited resolution. So those are good things. Downside, the cost. Obviously, they can look at other things while they are investigating you. That's a big issue and a big concern with OIG, and they're limited for the release that they can provide. They can not release you for False Claims Act liability. The DOJ has to be involved, and that happens. DOJ frequently does get involved with OIG investigations, and so it's not at the end of the world, but it often leads to higher settlement amounts. And so what you see with the OIG settlements is they're usually significantly higher when it comes to the dollar amounts, as opposed to CMS, which we're going to talk about now. Again, the benefit, you've got it tolls the deadline for you to report and repay. CMS does have discretion in determining settlement amounts, and frankly, historically these have been significantly lower than settlements through OIG, often based on the amount of the overpayment, not the amount of the reimbursement itself. And you can get a potential release. Now, the downside is that there's a very limited scope to that release, and that is it only releases your liability for that violation. But if you want a release of anti-kickback statute, False Claims Act, you're going to have to coordinate with, CMS is going to have to coordinate with OIG and the Department of Justice to get additional releases. And again, that's possible. It happens frequently, but the settlement cost is likely to go up. And so CMS is really good as far as it goes. But if you've got violations beyond Stark law, you're going to have to get other agencies involved. It can be pretty slow going. And it's going to be more expensive than just returning money to the MAC, which is the cheapest and fastest way to do this. Okay, and so the CMS settlements, we had my partner Kim Stanger looked at a few years ago and sort of analyzed all the settlement amounts, and he found that they were settling in some cases for 2 to 3% of the potential overpayments, and so you may end up paying $30,000, which is a lot of money, but it's a lot cheaper than say $3 million in potential overpayments. So that CMS is a good route to go if you just have a Stark law violation. Okay, so. With all that, not surprisingly, it is better to comply in the first place than have to find yourself in a situation where you have to go through these reporting and repayment procedures. You want to establish a compliance program. Make sure you have an effective compliance plan in place. If you don't have one, or if you haven't updated it recently, dust it off, pull it out, take a look at it, make sure that it's up to date. A lot of people put the compliance plan in place just to protect themselves in the event the government ever comes in and does an investigation after the fact. But that doesn't give you the benefit of a compliance program. What you really need is an effective plan that works, and then that you're working proactively so that you can avoid these problems at the front end. If you have an effective compliance plan, it usually works to your advantage too, because in a lot of the non-compliant situations we run across, it's usually situations where you're not getting enough money from the government. And so these compliance programs can really benefit you on the front end, both by keeping you out of trouble and getting you the reimbursement to which you are rightfully entitled. So it can benefit you in the long run in a number of ways. You want to make sure you have appropriate policies, procedures, periodic billing and coding audits, focus on the high-risk areas there. But you want to be proactive. There are multiple government resources on websites. Go to CMS. They've got resources to help guide your audit efforts. And then if you do run across incidents of suspected noncompliance, investigate. Investigate right away and make sure that is built into your compliance plan. As needed, engage outside counsel, other experts, auditors to come in and complete a thorough investigation, including quantifying the amount of any overpayments, and understand sort of in more detail, the things that we've just talked about, the various methods for reporting and returning overpayments with the accompanying risks and benefits. So before you go off half-cocked to OIG, is this a situation you'd be better off just going to the MAC? You've got to figure that out before you go down one path or the other. And then again, document. Make sure that you are keeping track of the diligence that you're exercising in any overpayment investigation. All right, if you think you do have a problem, don't do this. You do not want to sweep things under the rug. It's not going to get better over time. It's only going to get worse. Please do not sweep it under the rug. So if you have a problem, suspend payments or claims until it's resolved. Investigate the problem under your compliance plan. And again, as we just talked about, that can involve bringing in a knowledgeable attorney, which will help you to maintain attorney-client privilege during the investigation, which can be very, very helpful. You can bring in outside auditors, make sure that you are doing what you need to resolve this, and then implement corrective action as appropriate. It may not be enough to satisfy the agencies with what's happened in the past, but it sure does go a long way to put your issue in a good light. And so then if the repayments due, report and repay it, and consider self-disclosure to the agencies as appropriate. All right, if you're interested in getting more materials on this, we do have some things on our health law blog with past webinars, publications that some of which speak to this issue. We've got things that speak to virtually every healthcare issue out there. And so if you need more information, please check there. Again, please input any questions that you have. I will respond to them as quickly as I can, hopefully later today. But in any event, within 24 hours, I should have responses to questions that you all have. Thank you very much for participating in this. Have a wonderful day. And if you do have any questions, again, please put them in the question and answer dialog box on your web browser, and I'll get back to you with responses to those very quickly. Thanks, everybody, and have a great day. Bye.